Well, it's official. Canada is now the place where stand-up comedians can get ordered to pay damages for their material. Viva Frei, Montreal litigator turned YouTuber, and let me just share with you the story that I had yesterday. Does my breath smell bad? Yesterday, I spent 6.5 hours in the ER waiting to get x-rays for one of my kids because she decided to pull a Carrie Strug in gym class. Luckily, no broken bones or torn ligaments, just a nasty sprain, but let me just tell you about the experience in the waiting room. There were so many kids with so many germs and mucus and things coming out of their faces. There was one perfect porcelain baby right in front of us in the waiting line, cheeks all rosy, and I said, "Oh, what a cute baby you have." And she said, "Yeah, she's been barfing and diarrheaing for the last 4 days." There was another kid in the waiting room coughing so hard he would eventually retch, and I believe he actually vomited on the couch. And I was holding in my pee, but after 3 hours, I finally broke and went to the washroom, and who comes out of the washroom right ahead of me? That kid with the diarrhea and the vomiting for the last 4 days. And her mother's like, "Don't worry, I was just changing a diaper." A diaper filled with germ-infested diarrhea. Okay, I feel a little better having vented. Thank you for listening. Let's get to the subject matter of today's vlog, that being the order against comedian Mike Ward to pay $35,000 in damages to Jeremie Gabriel, a kid who he made fun of in one of his stand-up routines. Just to set the context, Mike Ward is a stand-up comedian. He's been doing stand-up comedy since 1993. Jeremie Gabriel at the time was a 9-year-old kid who suffers from something called Treacher-Collins syndrome. Treacher-Collins syndrome results in the malformation of the head, permanent deafness, I believe in the order of 80 to 90%, requiring the implantation of a permanent hearing device. Jeremie Gabriel, suffering from this condition, also wanted to be a singer, and so as part of his inspirational story of a kid overcoming this disability, he was allowed to sing for the Pope. He was also invited to sing for Celine Dion in Vegas. Basically, he became this inspirational story of a kid overcoming the odds to chase his dreams. In 2010, Mike Ward, the stand-up comic, was doing a bit called Les Intouchables, which is French for the Untouchables. The entire premise of the stand-up routine was that there are certain public figures in Quebec that are so holy that one cannot make fun of them. And as the paradigm examples of public figures who are so holy in the province of Quebec that no one can get away with making fun of them, Mike Ward picked on Celine Dion and Jeremie Gabriel in particular. In his bit, which you can find online, but it's in French, so you'll have to speak French to get it, and you'll have to speak Quebecois French to truly understand it. In his bit, Mike Ward misunderstood in that he thought Jeremie Gabriel was suffering from a terminal illness and that his being invited to sing for the Pope and Celine Dion was part of some sort of Make-A-Wish program. And in his bit, he said, "Look, you can't make fun of this kid for his singing," and then he goes on to make fun of the kid for his singing. He says you can't make fun of this kid for the way he looks, and then he goes on to make fun of the kid for the way he looks. And he goes on to the punchline that you can't make fun of this kid because he's living his dream as part of a Make-A-Wish, but 5 years later the kid is still alive. And part of the bit that got Mike Ward in a lot of trouble, and we'll get to it in a bit, is that he said, "Look, 5 years later this kid's still alive," and he made a joke about drowning the kid and the kid being invincible. All within the context of a routine labeled The Untouchables about public figures who are so holy in the province of Quebec that no one can get away with making fun of them. Call it humor, call it dark humor, call it not funny, call it whatever you want. It's not a question of approving or disapproving of what he said, it's a question of understanding the context. Jeremie Gabriel finds out about Mike Ward's bit. The kids in his school find out about Mike Ward's bit, and Jeremie becomes the object of ridicule at school. He feels ashamed, embarrassed, humiliated. Apparently he has suicidal thoughts at one point in time. In 2012, he files a complaint before the Quebec Human Rights Tribunal for violation of his charter rights, and the Quebec Human Rights Tribunal concludes that there was in fact a violation of Jeremie Gabriel's charter rights. And they order Mike Ward to pay Jeremie Gabriel $35,000 in damages. Moreover, they order Mike Ward to pay Jeremie's mother $7,000 in damages. All stemming from this stand-up bit in the context of Mike Ward's routine of The Untouchables. I did a detailed vlog breaking down and explaining that entire situation and the decision of the Quebec Human Rights Tribunal. I'm going to link that video right here. If you haven't seen that video, give it a watch before finishing this video, because this video will make a lot more sense if you watch that video. So the Quebec Human Rights Tribunal finds in favor of Jeremie Gabriel and his mother and orders Mike Ward to pay Jeremie Gabriel $35,000 and the mother $7,000. Incidentally, I should mention that some of the jokes Mike Ward made at the expense of the mother was that Jeremie didn't have the means for proper medical treatment because his mother was off squandering the money she was making off her son, buying new cars and extravagant items and the like. So that's what happens, and Mike Ward says, "Heck no, I'm not paying a penny in damages for doing comedy in the province of Quebec," and he takes the decision to the Quebec Court of Appeal. The Quebec Court of Appeal heard the decision in January 2019, and they just recently, last week, end of November, rendered their judgment on the subject. Now, for those of you who don't know, courts typically have a delay of 6 months from the hearing date within which to render their written judgment. And you know what lawyers do when courts don't render their judgments within that 6-month delay?
Absolutely nothing.
We sit there, we mumble to ourselves, we grind our teeth, and we wonder when the court is going to render its decision. Because the reality is, even if there may be a delay, the court doesn't really like lawyers who nag them. And if you want the court to render a decision in your favor, you're not going to be calling them up every day after 6 months saying, hey, when's our decision coming? When's our decision coming? Now, in total fairness to the courts, they deal with a tremendous amount of work. There are the summer holidays, which cause additional delays. And it was in reading the judgment of the Court of Appeal that I truly appreciated why it might have taken a little more than 6 months to render. 64 pages long, 2/3 of it was not the majority opinion, but rather the dissenting opinion. And I am making a prediction now. This matter is going to the Supreme Court of Canada, and the dissenting opinion of the Court of Appeal is going to be the majority decision of the Supreme Court. Mark my words. The truly fascinating thing about this entire Court of Appeal decision is not in the majority decision, it is in the dissenting opinion by Justice Manon Savard. The Court of Appeal decision is entirely in French, so I'm going to show minimal screenshots of the judgment because it will only be useful to anyone who speaks French. I'll do my best to refer to the paragraphs in case anybody wants to go and independently fact check my analysis of this particular decision, but let's get started with the easy part of this decision, the majority decision. Now, despite the fact that it is a split decision 2-1, there are a few things in the judgment that all three judges agree on, first and foremost of which is the standard of review of a judgment coming down from the administrative tribunal. And that is the starting point to understand this Court of Appeal decision. What is the standard of review of the decision that is itself in appeal? All three judges agree that the appropriate standard of review is that of the reasonable decision, meaning that these administrative tribunals that were set up by law specifically to deal with questions resulting from the Quebec Charter of Human Rights have a degree of specialty in the subject matter, and it is therefore not the role of the higher courts to usurp that specialty that was granted by law to these administrative tribunals. And that is to say that if the decision rendered by these administrative tribunals is reasonable, the higher courts are not going to intervene and overturn that decision. In order for the higher courts to intervene and overturn the administrative tribunal's decision, the conclusion to which they came would have to be unreasonable. So that is the threshold, the standard of review that the Court of Appeal has to adopt in its assessment of the original decision that is subject of the appeal. The other thing that all three judges agree on are the criteria that need to be met in order for there to be distinction in virtue of Article 10 of the Quebec Charter of Human Rights, and we'll read those provisions in a second. The standard of proof is balance of probabilities and not beyond a reasonable doubt, so it's the civil standard of proof of the discrimination in virtue of the Quebec Charter of Human Rights. In order for there to be discrimination in virtue of Article 10 of the Quebec Charter, 3 elements must be met. 1. A distinction, exclusion, or preference. 2. Based on one of the elements enumerated at Article 10 of the Quebec Charter. And 3. Which has the effect of undermining or compromising the individual's exercising of their human rights. And in paragraph 142 of the decision, the majority of the Court of Appeal basically sets out their position. Mr. Ward, can he, under the guise of humor and freedom of expression, say whatever he wants? No. The comedian, like all other Quebec citizens, must respect the Charter and its fundamental values. Must we therefore conclude that nobody can make jokes at the expense of handicapped people, or more particularly Jeremie Gabriel? The answer is no as well. All is a question of circumstances. Here, the administrative tribunal concluded that what was said exceeded the limits that a reasonable person must tolerate in the name of freedom of expression, and awarded damages to Mr. Gabriel and his mother. And to summarize the next 19 pages rather succinctly, the Court of Appeal ultimately concludes that the administrative tribunal's decision as relates to Jeremie Gabriel was itself reasonable, and that the appropriate threshold for the Court of Appeal to intervene has not been met. And as a result, they will not intervene in the decision rendered by the administrative tribunal as relates to the damages awarded to Jeremie Gabriel. That being said, as relates to the damages the administrative tribunal ordered Mike Ward to pay to Jeremie's mother, the Court of Appeal concluded otherwise and said that awarding damages to the relatives of someone whose rights has been violated under the Quebec Charter is a little bit of a stretch. And so the majority of the Court of Appeal granted Mike Ward's appeal in part, reversed the order as relates to the $7,000 to be paid to the mother, but confirmed the ultimate damages awarded to Jeremie Gabriel himself. And reading the decision, you can understand very easily why the majority came to this conclusion. The threshold to conclude that the administrative tribunal's decision was not reasonable is a very high threshold. And so in a way, it's very easy for the Court of Appeal to say, look, there's nothing unreasonable in that decision. It's a very reasonable conclusion given the fact pattern. Every case has to be determined on its own merits, and we are not intervening in this particular case. It is Justice Manon Savard who went out on the limb and I think is going to be vindicated if and when this gets to the Supreme Court. In the early portions of her dissenting opinion, Justice Savard rightly points out that there is a difference between discrimination and defamation. She even notes that discrimination in a way is even more difficult to prove than defamation, and that typically you don't have discrimination by mere virtue of the fact that someone remarks on someone else's handicap. Now, why is this all relevant? Because if it is in fact a case of defamation and not discrimination, the administrative courts don't have jurisdiction. They draw all of their authority from the Quebec Charter of Human Rights. And so if this is in fact a matter of defamation, it would be for the superior courts to adjudicate on and not the Quebec Human Rights Tribunal. Justice Savard then goes on to cite the relevant provisions of law, which I'll read right now. Article 3. Every person is the possessor of the fundamental freedoms, including freedom of conscience, freedom of religion, freedom of opinion, freedom of expression, freedom of peaceful assembly, and freedom of association. 4. Every person has a right to the safeguard of his dignity, honor, and reputation. 9.1. In exercising his fundamental freedoms and rights, a person shall maintain a proper regard for the democratic values, public order, and the general well-being of the citizens of Quebec. In this respect, the scope of the freedom and rights and limits to their exercise may be fixed by law. 10. Every person has a right to full and equal recognition and exercise of his human rights and freedoms without distinction, exclusion, or preference based on race, color, sex, gender identity or expression, pregnancy, sexual orientation, civil status, age except as provided by law, religion, political convictions, language, ethnic or national origin, social condition, a handicap, or the use of any means to palliate a handicap. Discrimination exists where such a distinction, exclusion, or preference has the effect of nullifying or impairing such right. Justice Savard summarizes the decision of the Administrative Tribunal, and at paragraph 52, Justice Savard reads as follows, again a loose translation. The appellant reproaches the administrative judge of having failed to perform any comparative or contextual analysis to come to the conclusion of any distinction. Furthermore, the appellant adds, simply referring to the plaintiff's handicap is insufficient to conclude that the discourse at issue was based on that handicap, given the context in which these words were spoken. I share the position of the appellant. And Justice Savard concludes that simply by referring to an individual's handicap does not create the distinction required for by law in order for there to be discrimination. In fact, at paragraph 58 of her decision, Justice Savard rightly notes that even the Administrative Tribunal judge noted that Mike Ward did not pick on Jeremie because of his handicap, but rather because he was a celebrity. And the Administrative Tribunal judge, after recognizing that Mike Ward was not picking on Jeremie because of his handicap per se, but rather because he was a public figure, nonetheless concludes that there was a distinction based on the handicap by virtue of the fact that Mike Ward mentioned Jeremie's handicap. And Justice Savard concludes that mentioning someone's handicap might be defamatory, but it is not discriminatory. And why? Because Article 10 protects the full exercise of one's rights and freedoms, and that merely referring to characteristics of protected groups is not necessarily itself discriminatory. And Justice Savard furthermore concludes that there was no appropriate analysis of the context of the situation in which Mike Ward said the things he said. Paragraph 77. In my opinion, this real equality does not require us setting up restrictions that might refer to personal protected characteristics of public figures, when these characteristics are at the heart of the public figure themselves. And this is the crux of it. Jeremie Gabriel became famous as a result of his overcoming his particular disability in order to reach his dreams. His particular handicap was inextricably related to his very identity as a public figure. Contextually, therefore, it's impossible to dissociate Jeremie's handicap from Jeremie's identity as a public figure. The other thing that Justice Savard concludes is that merely making jokes that refer to Jeremie's handicap does not itself qualify as a distinction, preference, or exclusion under the law. Justice Savard then goes on to analyze and distinguish what seems to have been a core judgment that the Administrative Tribunal relied on in its decision. Caligo International Inc. Apparently in this case, an employer was angry about what they felt to be the uncleanliness at the workplace, and they therefore summoned some of the employees in order to address this issue of uncleanliness. The only problem is that the employer only summoned the Chinese employees because they only attributed the issues of uncleanliness to the Chinese employees themselves. And so the employer summoned a meeting of only the Chinese employees in order to reprimand them and them only for what they felt to be the uncleanliness at the workplace. And here Justice Savard concludes that there was in fact a distinction, preference, or exclusion under the law that did not exist in the situation of Mike Ward vis-a-vis Jeremie Gabriel. And to fully appreciate the distinction between that Caligo decision and the Mike Ward Jeremie Gabriel situation, I'm going to translate paragraph 132. And incidentally, this is a loose translation, so for anybody out there who's proficient in English and French, don't jump on me in case this is not a word-for-word translation. That being said, if we understand the objective of Article 10 of the Charter, which, I remind you, is the basis of plaintiff's claim, we cannot argue that this promotes discriminatory discourse, nor does it attempt to promote any public belief pursuant to which the dignity of the plaintiff, as a result of his handicap, is of a lesser value. Likewise, the words at issue do not attempt to promote any sentiments of disgust vis-a-vis the plaintiff, nor do they seek to denigrate handicapped peoples, nor do they promote any improper stereotype to them. And that, according to Justice Savard, is the context through which the Administrative Tribunal ought to have interpreted Mike Ward's bit. Mike Ward, through his routine, was not seeking to denigrate handicapped people at large. He was not promoting any negative sentiment vis-a-vis Jeremie in particular. According to the Administrative Tribunal themselves, Mike Ward wasn't even picking on Jeremie Gabriel as a result of his handicap, but rather because he was a public figure. It just so happens that his identity as a public figure was intimately related to his handicap in the first place. But it does not qualify as discriminatory under Article 10 of the Charter to make jokes on the basis of that public identity. And I believe that Justice Savard's analysis, which is much more difficult than that of the majority for the Court of Appeal, is in fact the correct one. But there is one more thing of incredible value that Justice Savard notes in her dissenting opinion. Justice Savard criticizes the Administrative Tribunal's decisions in that they regard Mike Ward's argument of freedom of expression as an exception and not itself a Charter right. Insofar as freedom of expression is itself a guaranteed charter right, it cannot be regarded as a mere defense to the complaint. And here I'm just going to translate the highlighted section of a judgment referenced in paragraph 138 of her decision. In short, we cannot act on our discriminatory convictions, but we can always express them without breaching a certain threshold. And that goes back to the argument that uttering words that remark on an individual's handicap is not a preference, exclusion, or discrimination under the Quebec Charter. On the contrary, it is itself a guaranteed right under the Quebec Charter. And Justice Savard obviously agrees that no damages should have been awarded to the mother. All right, that's it. And it does look like this is going to go to the Supreme Court of Canada because Mike Ward has openly said that he would sooner go to jail than pay any portion of this judgment. The Supreme Court has to agree to hear it, but I think they will because this is a very serious issue with potentially very serious consequences. As it is, Canada has become something of an object of ridicule, if only to the United States, who are now making jokes about the fact that stand-up comedians better not come to Canada to do their bits. And while I agree that this may be something of a context-specific decision, there are nonetheless broader principles of law that need to be addressed and clarified by the Supreme Court of Canada. Is Canada going to successfully kill stand-up comedy? What do you think?
Probably.
No. Pessimist. All right, and that is it. If you like my content and my videos, be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to support the channel, there are merch links, PayPal links in the pinned comment. But above and beyond all else, share my channel. That is the greatest gift that anyone can give that doesn't actually consist of out-of-pocket expenses. And now you know your vlog. Peace out. Booyah!